Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about SB3234, which became law in California in January of 2021 as Penal Code Section 1001, and it applies to misdemeanor diversion. And for the longest time in California, you would see diversion statutes, PC1000 for low-level drug offenses, and once in a while you'd have deals with the district attorney where you enter a guilty plea and you put off sentencing a while, and then if you do what you're supposed to do, you get your plea back and the case gets dismissed, and if not, you get sentenced to what you pled to. Then mental health diversion came into play a couple of years ago, where you don't have to plead guilty to anything if you meet the criteria for mental health diversion, and a judge believes that you do. And then what happens is they basically put a pause in the proceedings for several months, and if you do A, B, C, D, and E, remain law-abiding, the case may get dismissed altogether. Well, there was a lot of types of offenses, misdemeanor offenses, that were sort of not really included there, right? So what do you do if you have someone that may not have a mental health diagnosis, that may not be eligible for Veterans Court, it may not be a low-level drug offense? And that's where California, codified in PC 1001, giving judges the opportunity to offer defendants diversion over the prosecutor's objection, and that's really key. So I want to focus on this video now, talking about what that really means for you if you're facing a misdemeanor charge in California. Well, it means a couple of things. Primarily, it means that you could go to the judge, or more importantly, your attorney could go to the judge with a laundry list of things that he or she proposes that you do in order to earn an outright dismissal of the case. So let's say you're charged with one or two misdemeanors and the district attorney, in your view, is being unreasonable, right? Maybe in most views they're being unreasonable. And your attorney presents all the good things you've done in your life, all the good things you've done since the alleged offense occurred, and asks the court to entertain its discretion and grant you diversion. Well, if the court does that, then they basically stop the proceedings. So you don't have to plead guilty. Everything sort of stops at, let's say, like a readiness conference. And the judge will say, okay, come back in 18 months, come back in a year, whatever the case may be. I think it's up to 2 years is the maximum they can put it out for. If you do A, B, C, D, and E, stay out of trouble, the court will dismiss your case pursuant to Penal Code Section 1001. Awesome. And even better than that is that the arrest record will go away and deemed to have never occurred for many, if not most, background checks or questions, have you ever been arrested? So really, really important. The issue is, how's it being used, right? It's early in the game in 2021 to sort of make that determination, but what's important is that if you find yourself facing misdemeanor charges, you and certainly your attorney need to be aware of this and need to use it to your advantage. Well, how do you use it to your advantage? Well, use it as a bargaining chip with the district attorney. If it's a viable option where you think a judge may dismiss the case outright, you may be able to get the district attorney to come off their offer, which may have been unreasonable to begin with, and get you a much better outcome without risking, hey, what if a judge says no, then I'm stuck, right? I'm stuck with the DA's bad offer. So your attorney should be able to use that to your advantage, and that's a question you want to be asking your lawyer. Hey, am I eligible for misdemeanor diversion? There are certain offenses that might not be, but you want to ask that question of your attorney, and you want to be satisfied with her explanation to make sure that you're getting the best outcome possible. Even more so during COVID, with court closures and court backlog that's going to go on for years. The hope is that judges will use Penal Code Section 1001 to the advantage of basically settling some of these cases and getting some of these cases out of the system, these low-level offenses that can mean the world to you as the defendant. But in reality, so many of you have learned a lesson, if there's a lesson to be learned so soon in the proceedings. So let me tell you an example of a very similar type thing that happened in 2004 to me. Okay, I got arrested in 2004 in New Orleans and offered a similar type outcome, right? District attorney said, hey, listen, we're not going to file charges at all. Okay, so the district attorney said, we're not going to file charges at all for 6 months. If you come back in 6 months and show that you did this, 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 and this, which is pretty much what you would have had to have done if you got convicted anyway, we're not going to file charges. Okay? I'm 22, 22 years old, turning 23 years old at the time, and that was an opportunity that I jumped on. And the lesson that needed to be learned was learned when the handcuffs went on. Not when I had to go to court, not from a tough talking prosecutor or a judge trying to give me a lecture. And for so many of people who are charged, especially for the first time with a misdemeanor, you know, oh, what's the big deal? It's just a misdemeanor. What's the big deal to you? It's a big deal for your reputation. It's a big deal for your future. Listen, we get it. I've been there. You know, the shame that you feel and the uncertainty for your future. So make sure you're taking advantage of the law. Make sure you're bringing it to the attention of the courts because they might not even know. Every judge may not even know. And it's up to you and your attorney. Otherwise, no one's going to know and you're not going to be able to avail yourself of the opportunities that are out there under the law effective January of 2021. So if you have any questions about misdemeanor diversion or any case related to a criminal court matter, particularly in San Diego County, feel free to give my firm a call, 619-295-3555.